Good afternoon, students. Today's Constitution of India topic is High Court. So already we have a introduction on the judicial system in India, which is very powerful, equal to the legislative system. In that already in few classes we discussed about the basic anatomy and the responsibilities of judicial systems. And now in this session we are going to discuss something about the High Court. So this is coming under the Unit 3, the Judiciary, and the CO statement is shown to you. First of all, a simple introduction about the judicial system. As I told earlier, it's having equal power like your legislative system, and the high courts especially are coming under the state judicial system. So each and every state in India is having a high court, but in some places 2 or more states are commonly having a single high court, and the Supreme Court is the boss to all of these high courts. And for the union territories also, they are having the judicial power to the near states. But in the case of Delhi union territory, it's having its own high court. So the high court scheme is actually originated in the year 1862, and it is first established in Calcutta, Bombay and Madras. Currently in our country we are having 25 number of high courts. Out of these, 3 high courts are having jurisdiction more than one state. And as I told earlier, Delhi is having a separate high court, however it is an union territory. The other union territories are having common high courts. And in the case of Jammu, Kashmir and Ladakh are having a common high court. And the other union territories fall under the jurisdiction of different state high courts which are all near to them. For example, the union territory Pondicherry is coming under the jurisdiction of Madras High Court. And how a high court is formed, how the judges and the chief justice are appointed. So we can see these things. And in the every high court, whether it is a common for 2 or more states or union territories or exclusively for a particular state, it is having a chief justice as the chief of other judges. This chief justice is appointed by the president, and there is no specific rules and regulations are given in the Constitution of India to define the number of judges in a high court. Based on the workload and based on the population strength of a state or a union territory, the president will decide the number of high court judges. And how the judges are appointed. Actually, the judges are appointed by the president. So president is having more influence in the judicial system of our country. In the further slides you will see what will be the influence of a president in each and every aspect of the high court. The chief justice of the any high court is appointed by the president by discussion with the chief justice of India, that is the chief justice of the Supreme Court, along with the governor of the particular state. So before appointing a chief justice of a high court, the president will discuss the chief justice of India and the governor of the particular state. After that only a particular person will be appointed as a chief justice to the particular high court. So after that, the other judges who are all coming under the chief justice in a high court will be appointed by the president as well as by the chief justice of India and the governor. And this time the elected chief justice of the particular high court is also involved in the selection process. This process is standardized by a lot of amendment acts by the judicial systems. So the second judge's case 1993, the Supreme Court instructed the appointment of judges should be made by the Chief Justice of India. But in the third case 1998 related to the appointment of the judges, the Supreme Court instructed the Chief Justice of the Supreme Court to select the judges for the High Court by consulting a collegium of two senior most judges of the Supreme Court. But this collegium system is further replaced with the National Judicial Appointments Commission NJAC in the year 2014 through the 99th Constitutional Amendment Act 2014. However, after 2015, the collegium system is again started to follow to select the judges in the High Court. And what are all the qualification a person need to be elected for a judge is? He should be an Indian citizen, and he should have been an advocate of a High Court of any state for 10 years. He need not to be acted as a judge in advocate in the High Court in a particular state where we are targeting him to appoint as a judge. In any High Court, he should serve for 10 years. And these are all the points which are all in the pledge he has to be taken during the appointment of a High Court judge. He should accept true faith and allegiance to the Constitution of India. He should maintain the sovereignty and integrity of India. To properly and loyally and to the best of his ability and knowledge, he has to serve his duties without fear or biasing. So this is the very important point. A judge, lawmaker should have strength to act without fear and biasing, and he has to uphold the Constitution and the laws. And what are all the salaries and allowances for the High Court judge? It also determined by the Parliament. In the year 2018, the salaries of the Chief Justice and other judges of High Court are revised. For the Chief Justice, the salary is revised from 90,000 to 2.5 lakh per month. And for the other judges, the salary is revised from 80,000 to 2.25 lakh per month. In addition, the Chief Justice and other judges in the High Court are provided with free accommodation and other facilities like medical, car, telephone, and so on. So the retired Chief Justice and judges will get 50% of their last drawn salary as monthly pension. And what will be the working years of the judges? That is, the tenure of the judges is 62. So up to the age of 62 years, the particular High Court judge can serve as his duty in the High Court, whatever it may be, whether it is he is a Chief Justice or other judge, he can work for up to 62 years. And in between that, if you want to resign his job, he can resign his office by writing to the President. And sometimes purposely he can be removed from his office by the President on the recommendation from the Parliament. This point will be explained later. And he should vacate his office when he is appointed as a judge of the Supreme Court or when he is transferred to another High Court. So a particular person who is appointed as a High Court judge serving in a particular state's High Court is provided with an accommodation in that area, and he has to vacate that house when he is appointed as a judge in the Supreme Court or transferred to the another High Court. And what are all the rules for the transferring of the judges? Actually, the President is having the power to transfer a High Court judge from one High Court to another High Court after discussing with the Chief Justice of India. But in the year 1977, the Supreme Court instructed that transferring of a High Court judge should be in the moral reason and it should not be based on giving punishment for any activity. And acting Chief Justice scheme. What is the acting Chief Justice scheme? It's a temporary allotment for a Chief Justice post. For example, if a Chief Justice is in a High Court is transferred to another High Court, or he appointed as a Chief Justice or a judge of a Supreme Court, then automatically the place will become vacant. So to selecting a permanent chief justice for that particular high court, the president can appoint a temporary or acting chief justice for that high court. So this is possible, and these are all the possible grounds where we can select the acting chief justice. The office of the chief justice of the high court is vacant, and the chief justice of the high court is temporarily absent, maybe due to some medical reasons or due to some other reasons. If the office is temporarily absent for some more time than month or a few years, then acting chief justice may be allotted, and that temporary time is also for 2 years only. What is acting judges? So like acting chief judge, sometimes a judge of a high court can be replaced with the acting judge after the transferring of particular judge in the high court. The position become vacant. In order to temporarily fill that vacant position, acting judges will be appointed by the president and chief justice, and this should be happened for the proper qualified person only, and this can be happened due to a particular judge unable to perform the duties of his office due to absence or any other reason. And if he temporarily allotted as a chief justice, then automatically his judge position will be get vacant. So in order to fill that position also, temporarily some other person can be allotted as an acting judge, and an acting judge holds office until the permanent judge resumed to his office. However, the acting judge or normal judge, any judge can work only up to the age of 62 years. And a special case, during some special cases, the chief justice of high court can request to the retired judges who are all reached or 62 age, and they called by the chief justice of India or the chief justice of the particular high court to temporarily act as a high court judge. So this is because of some extreme workload, or in order to handle a special case, this kind of retired judges can be requested by the chief justice to perform the short time jobs. However, it is a short time job. The so-called retired judges are also enjoy the all jurisdiction powers and privileges which are all applicable for the judge of the high court, and this should be happened with the consent from the president only. And under which ground a high court judge will be removed by the president? So a judge of the high court can be removed from his office by an order released by the president, but that order should be passed by the parliament, by the major MPs. So without the consent from the parliament, president cannot alone remove any judge from the high court. So that report must be supported by the special majority of each house of the parliament. And the reason of removal are to proved misbehavior or incapacity. Under these reasons only, president can remove a judge from the high court from his service. The Judges Inquiry Act in 1968 having a detailed procedure on under which grounds and which procedure a high court judge can be removed. The name of that procedure book is Process of Impeachment. So these are all the things I planned to discuss today regarding the high court. Thank you.